Justice Aafia Siddiqui, former Chief Justice Pakistan, Mr. Rendition, former Attorney General USA, Senator Iqbal Haidar, Justice Retired Mr. Anwar Mansoor Khan, President Sindh High Court Bar Association, Mr. Anis Harun, Dr. Fawzia, Shamim Kazmi, distinguished guests, ladies and gentlemen. The issues of enforced disappearance or missing persons and interstate rendition of an accused without due process of law are some of the most tragic aspects of our civilized world. People do not disappear by themselves. There is always a tragic reason behind such disappearance. It can be caused by several circumstances including a conflict, military operation, an accident, but in most cases a person disappears due to a deliberate action of persons linked to state authorities. Tens of thousands of people in more than 70 countries throughout the world have vanished following their arrest. In most of these cases, authorities deny their involvement, hide the truth, and protect the perpetrators. These cases are today recognized as enforced disappearance. The circumstances under which these disappearance occurs differ greatly from case to case, from country to country. In Pakistan, it is infringement of fundamental rights guaranteed by Articles 4, 9, 10 and 25 of the Constitution. According to common perception, an enforced disappearance takes place when a person is arrested, detained or abducted by the state or agents acting for the state who then deny that the person is being held or conceal their whereabouts, placing them outside the protection of law. It persists in many countries all over the world, having been a continuing feature of the second half of the 20th century. In several cases, a detainee who has disappeared never released, and his fate remains unknown. His families and friends may never find out what has happened. The commission set up for tracing missing persons in Pakistan has not proved to be an effective organization. It is dependent on police or agencies' report. This commission has no police powers and has no independent agency to probe, search and locate the missing persons. In Pakistan, the first case of rendition was that of Mir Amir Kasi in the year 1997 was unauthorizedly and illegally handed over to US authorities by the Pakistan government without resorting to the extradition proceedings as provided by the Pakistan Extradition Act 1972. Kasi was alleged to have committed shootings on 25th January 1993 near the entrance of CIA headquarters in Virginia, USA, where 2 CIA employees were killed and 3 others wounded. He fled the USA and was placed on the FBI's 10 most wanted fugitive list, sparking a 4-year international manhunt. It was claimed that he was captured by FBI agents in Pakistan in 1997 and rendered back to the United States to stand trial. Perhaps this was the first instance when the sovereignty of Pakistan was publicly breached. This illegal practice of rendition reached its height during the military rule of General Pervez Musharraf, who has confessed committing such crimes in his book titled In the Line of Fire. The cases of enforced disappearance also reached their height during the tenure of General Pervez Musharraf and are still being practiced in Pakistan by the intelligence agency who claim to be above the law. The Extradition Act 1972 and the Pak-US Extradition Treaty have been put to naught. The case of Dr. Aafia Siddiqui is one of the worst examples of enforced disappearance, and thereafter her rendition to the US authorities which was done in clear disregard of the rule laid down by the US Supreme Court in the case of Simon Green versus John S. Shine, where the US Supreme Court laid down the principle governing the international extradition. This view of US Supreme Court was reiterated by a learned full bench of Supreme Court in the case of Muhammad Azim Malik, and I quote, "There is such a general acknowledgement of this necessity of such treaties that of late, and since the facilities for the escape of criminals have so greatly increased, more civilized powers have entered into conventions for the mutual surrender of persons charged with the most serious non-political crimes. These treaties should be faithfully observed." It was remarked by the US Supreme Court. "These treaties should be faithfully observed and interpreted with a view to fulfill our just obligation to other powers, without sacrificing the legal or constitutional rights of the accused. The crime of enforced disappearance or unlawful rendition is not only an offense against humanity, but at the same time it is also an offense against the sovereignty of a country. After the Second World War, the international community has focused its attention and enacted several international treaties and charters which are the milestone to prevent the cases of enforced disappearance. They are 1992 Declaration on the Protection of All Persons from Enforced Disappearance, second, 1994 Inter-American Convention on Enforced Disappearance of a Person, and lastly, 2006 International Convention for the Protection of All Persons from Enforced Disappearance. The 2006 International Convention has made enforced disappearance a crime under international law and included even those cases of disappearances which arises from war crimes or any public emergency. I will skip those. I have quoted those portions of 2006 Convention. Even for lawyers, disappearance and interstate renditions are a complex phenomena involving various dimensions. Over the last 30 years, relatives of the disappeared persons, activists, NGOs and the international community have developed and advocated for remedies to combat disappearance. However, in Pakistan, every case of rendition and enforced disappearance infringes a range of local laws like Extradition Act and the fundamental rights, as Mr. Anwar Mansoor has rightly pointed out. I will skip that because I have been given a notice. What I would suggest, that now in the Extradition Act it is the time that the Pakistan government and all other governments of the world, they should introduce a penal provision where if a person is rendered back to another or surrendered to any other country, such person should be brought to justice and should be convicted. And this is the mandate of Article 7 of the 2006 International Convention. Let me read my conclusion. I have this much time. One thing I was not able to understand, Mr. Ramsey Clark is here. From 1 year back when Dr. Fauziya brought me that decision of the court, after pronouncement of the decision by the so-called jury that she is guilty, the defense counsel has submitted their final submissions. And there they have stated that at the most, the offence proved against Dr. Aafia Siddiqui was an offence punishable by with 7 years imprisonment. And in the end, The defense counsel pleaded for 12 years of imprisonment, unlike in our country, in India, Bangladesh, and even in Britain. There the defense counsel always claimed for mistrial or for acquittal of the accused. But I was shocked that the defense counsel, they pleaded that she be convicted for 12 years. I don't know. The International Convention for the Protection of All Persons is an international document. Many countries, 91 states have signed this convention. 32 have ratified, and America, USA, they have denied to sign this 2006 convention, and including United Kingdom, Spain, Italy, Germany and Netherlands. All these countries claim to be civilized nations and followers of the rule of law. Members of these civilized nations are, allow me to say, Mr. Ramsey, are bigger perpetrators of the offences of unlawful renditions and forced disappearance.